All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save this United States and His Honorable Court. This Honorable Court is now in session. Please come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals to our virtual oral arguments. Our courtroom clerk and technicians have done everything they can to ensure that this goes as smoothly as possible, but we ask for your patience in the event that we do encounter any technical glitches. We have two cases for argument this morning. The first is District of Columbia Public Schools versus Marsha Karim versus Department of Employment Services. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Right. Ms. Van Zyl?
Good morning, and may it please the court, Caroline Van Zyl on behalf of the District of Columbia Public Schools. Because this case involves a cross appeal, I intend to spend 5 minutes of my time on DCPS's affirmative appeal, and after counsel for Mr. Karim or Ms. Karim takes 12 minutes to offer his response and initial presentation on cross appeal, I will spend the remaining 10 minutes of my time in response to the cross appeal and rebuttal for our affirmative appeal. After that, counsel for Ms. Karim should be afforded the 3 minutes that he has reserved for rebuttal in the cross appeal. Starting then with DCPS's affirmative appeal. The ALJ in this case awarded Ms. Karim a 17% impairment rating based on medical evidence that was thoroughly evaluated and explained. The computation for that 17% impairment is clear. By contrast, the ALJ made a clear error when adding an additional 10% rating. She failed to explain completely how she arrived at her percentages for pain, weakness, loss of endurance, and loss of function. And that is a key error because, as this court said in the Jones case, it needs to be clear for this court to engage in meaningful review how an administrative...
I'm sorry if I could jump in right there on the Jones case. In the Jones case, there was really nothing said at all by the ALJ in explaining or in attempting to explain how the ALJ in that case arrived at a rating. Here we have significantly more than was in the Jones case. And I am not aware of other cases, and you could maybe point me to them, where we've given some more specific guidance as to what more the ALJ should have said here. It's clear that she was grappling with this whole issue of the adduction versus adduction and the rotation and the impact of that based on some of the conflicting medical reports. So what more should she have done, and what's your basis for saying that?
Well, I think, again, under Jones, you just have to explain how you got to the specific percentage. So let's take weakness, for example. Now, the easiest way to explain how you get to a percentage is to link it to some medical report, and that's what's often done in these cases. Here, that was not possible because neither of the medical reports gave a 4% rating for weakness. In fact, Dr. Rothschild's report gave a 0% impairment rating for the Maryland 5 factors. And Dr. Sabloff simply included some of the factors, pain and lack of endurance, not even weakness, right? Only 2 of the Maryland 5 factors, he said.
But Dr. Sabloff did attribute a 10%. 10% was the amount that he awarded to those two factors, the additional factors, and that's what the ALJ ended up adopting. And now it's true that she broke it down in a way that Dr. Sabloff did not quite do, but she also did something else. She said, this is also accounting for the internal and external rotation factors that I didn't want to resolve the discrepancy between the doctors. I'm just going to smuggle it in here to this 10% additional factors test. Doesn't seem like such a bad way to do it to me.
Well, so that is not exactly what either the ALJ or CRB said. I mean, I think it's notable that the ALJ did not say that she was adopting Dr. Sablov's, supposed 10% rating for the Maryland factors. And I say supposed because that 10% factor is really something that counsel for Ms. Green appears to have backed out of the 35% impairment rating. If you look at Dr. Sablov's actual report at A181, it just says 35%. It gives some ratings for loss of motion, and then it says, I'm also including pain and lack of endurance. And there's a projection that those amounted to 10% because they certainly weren't accounted for by Dr. Sablov in his range of motion ratings. But I don't think that there's any indication that the ALJ was relying on that after the fact guesstimate of what Dr. Sablov was awarding for the Maryland 5 factors. I also think, turning to the order that is actually under review here, which is the order of the Compensation Review Board, you mentioned that the Compensation Review Board seized on this language from the ALJ about abduction and internal and external rotation. But again, even assuming that could be part of the basis for this award under the Maryland 5 factors, and setting aside the fact that at least abduction was already accounted for in the impairment rating for loss of range of motion. If you look at Dr. Rothschild's ratings, right, the CRB says a review of Dr. Rothschild's examination shows a detailed analysis of abduction and internal and external. So clearly the CRB thought that's where the extra 10% was coming from. But if you look at his actual ratings, he gives a 6% rating for abduction and only a 2% rating for internal and external rotation. That's 8%. That's not 10%. And so I think, particularly if you zoom in on the CLB's or CRB's decision, which is what's under review here, it can't be anything other than arbitrary or capricious. The evidence it cites as a basis for this 10% impairment rating doesn't add up to 10%. And this court faced a similar situation in Bowles, where it said,
I mean, it adds up to, if you add in some of Dr. Sablov's additional factors. If you say, look, you've got Sablov is saying internal and external rotation amounts to 8%. And Dr. Rothschild for internal rotation gives 2%. It's tough to say exactly where that falls, but when we factor in pain, lost endurance, the things that Dr. Sablov says, we'll call it 10%, and that seems to be, has some substantial basis in the record. It's tough to be that much more precise with such ethereal concepts, I guess, so back to the Chief's question, what did you want the ALJ to say? This is a 2% pain because, what is the more precise way to articulate that?
Sure. Again, I mean, I think that the ALJ would have been on firm footing if she had said, I'm awarding 0% because that was Dr. Rothschild's rating. But, that's not to say that she would have been limited to that. If she had wanted to add, say, 2% for pain, I think what you would need to say is something like, well, the evidence in the record shows that there was something other than minimal pain here. So I'm going to award 2% rather than 1%. But it was not so extreme as to, and again, you have to link this to industrial loss of use, right? So it was not so extreme as to have a grave impact on her industrial loss of use. And sorry.
I didn't mean to interrupt you. I'm mindful of your time because I know that there are some other issues that I know we are interested in exploring further with both you and Mr. Taylor. Was there anything else that you wanted to say on this point before we move to the Mr. Taylor for his cross appeal, I guess, cross petition, excuse me.
Thank you so much, Your Honor. The only thing that I would say is, I think that coming up with this explanation in the absence of a rating from a doctor is challenging. This is, as the court said in Jones, not an exact science, but this court has demanded that the ALJ, if it's going to take that route, articulate how it arrived at percentages such that this court can engage in meaningful review, which is particularly important when you're dealing with a technical issue like impairment and workers' compensation. So with that, I will reserve the remainder of my time and turn it over to counsel for Ms. Green.
All right, Mr. Taylor? Mr. Taylor, you have to take yourself off mute, please.
Thank you, appreciate it. Robert Taylor, representing Marsha Kareem, petitioner and intervener. The District of Columbia, the employer, relied on Jones and Bowles, but those cases can clearly be distinguished in that the judge in that case failed to assign specific percentages to the Maryland Five. That is not true in this case. The judge actually took each of those Maryland Five factors, considered them, and assigned individual impairment ratings to those adding up to 10%. The judge also felt it was particularly reasonable to give 10%, given that in the agreed upon part where the doctors were looking at range of motion, she was not able to award any percentage for either internal rotation or external rotation. And so she felt that it certainly was reasonable to consider that when looking at industrial loss of use. And there should have been some percentage awarded for internal and external rotation, which she felt was reasonable to put into the 10% on the other Maryland Five. So Bowles and Jones clearly are distinguishable. There was no argument by counsel that it was inappropriate for the ALJ to consider the Maryland Five factors. I'm going to assume that she is not waiving that argument, and so I'm going to go ahead and address it. I think it's important to note that that argument was raised for the first time on appeal. They certainly had every opportunity to raise that argument below. In fact, the CRB in the decision of February 3, 2017, at footnote 2, which is found in the joint appendix at page 55, alerted the employer that they had not contested or challenged the five factors as being relevant to the award as they relate to a significant loss of industrial use, particularly the claimant's ability to lift, carry, push, pull when using her arm. Even though the CRB had alerted the employer to that fact, the employer did not subsequently request a reconsideration. When the case went back down to the ALJ, did not raise it with the ALJ. When the case went back up to the CRB, did not raise it with the CRB, and raised it for the first time on appeal. Obviously, I argued that it was a first-time issue being raised on appeal. Their counter was that, well, this was simply one more argument being made in favor of or in support of an argument made below. But when one looks at how they fashioned the issue in this case, the issue was whether the ALJ properly explained the ratings. Whether the ALJ may consider the Maryland Five is a totally separate issue and needed to be raised below, particularly since not having raised it, the CRB had no reason to expound upon it. In any event, under Dent, Degussy, and the 2016 CRB case of Larry Barron, and the 2015 case of William Mosby versus DC Department of Consumer and Regulatory Affairs, we see that it's not only appropriate to consider those Maryland Five, but additional factors can be considered, such as wages, the existence or non-existence of wages, social activities, as they may reflect on an ability to do work. And so it's appropriate to consider on those, not only those Maryland Five, but also other factors when determining what is really an attempt to compensate for a loss of wage earning capacity, a loss of industrial use. And it's, I think, important that deference be given to the CRB in terms of how they felt it was necessary for the ALJ to explain the ratings, and they certainly felt that it was an appropriate way for the ALJ to explain it. And I think that is entitled to deference.
Okay. Mr. Taylor, let me jump in here just to refocus where we are, since you are both counsel for the intervener and cross petitioner, Ms. Karim. Are you going to launch into any of your other arguments at this point, or do we want to pivot back to Ms. Van Zyl for her?
I cannot see the time very well.
I think we might have not reset the time for Mr. Taylor, Chief.
Oh, okay.
It says it's 1 minute 38 seconds. I'm not.
And you just started. That's so we're going to reset the time at 12 minutes. That's what we said? Could I ask our courtroom clerk to please reset our time to 12 minutes for Mr. Taylor, please? Thank you.
In fact, yes, Your Honor, I was just ready to move on to the
Okay.
issue of whether the CRB erred in reversing the ALJ's award of compound interest. The issue is whether the CRB erred in reversing the ALJ's grant of compound interest. Ms. Green contends that in the face of an ambiguous statute, 28-3302, and even in the absence of a statute under OHR v. DOC 40A3rd 917, the ALJ and the CRB have the authority to interpret that statute and the CMPA in accordance with the law, including the law of this court, as it's evolved and brought this jurisdiction in line with modern jurisdictions that award prejudgment interest on compound basis. ORM should not be heard to argue that an ALJ did not have authority to interpret ambiguous statute 28-3302 in terms of whether the interest was simple or compound. ORM itself interpreted that statute when it subsequently issued Emergency Rule 7 DCMR 3361, which was effective April 28, 2017, and Final Rule 7 DCMR Section 161, which was effective July 7, 2017. An agency walks on two legs in doing its job. One, it issues regulations, and two, since those writing those regulations can't foresee all issues, it engages in adjudication to apply the regulations, clarify them, and clarify and interpret the enabling legislation when necessary. To find in this case that the ALJ could not interpret and clarify an ambiguous statute would be to cut off one of those legs of an agency's ability to do its job.
Yeah, but counsel, I mean, the CRB in Harrison, in exercising its adjudicatory capacity, took a look at this, looked at Rastall, looked at Burke, and said, under this statute, which is silent on the issue, we believe the better rule is to award only simple interest, and gave some pretty good reasons for it. It seemed like reasons that there's nothing in the statute that it really contravenes. So what's wrong with the CRB announcing a uniform policy in Harrison? There's some value in uniformity, saying, we're not going to do this on a piecemeal basis. We, CRB, are hereby saying this is going to be a simple interest calculation. What's the problem with that?
The problem with that is the CRB in Harrison was saying, we feel we need to have a statute to allow us to award compound interest.
It didn't say that, counsel. I mean, I understand that you select an excerpt from Harrison that says that, but they grapple with Burke quite a bit. And then they say, this is not really a tort case, workers' compensation cases are different. And it gives some reasons to apply simple interest rather than compound interest. I'm not sure how compelling those reasons are. I'm not sure that I find them so persuasive. But they don't adhere to this bright line Rastall rule that absent statutory authority, it needs to be simple interest. They do a much more in-depth analysis than that.
They did seem to indicate that they felt there was a need for the DC Council to weigh in on this issue. And in the absence of that, they were simply going to stick with the Clark case. And unfortunately, the Clark case did rely on Rastall. this court in Burke had said Bristol is inopposite to a personal injury case, and therefore probably inopposite to a compensation case. And it would have been appropriate had they done the analysis and been willing to recognize that they had the authority to award compound interest, because it has been found, and interest has been found to be part and parcel of an award. And
Counsel,
certainly it is commensurate with assuring that the humanitarian and beneficent purposes of the act are satisfied.
counsel, I guess to follow up on Judge Steele's question, I mean, why isn't this an instance where they looked at the statute, they said it's ambiguous, and then they interpreted it and gave a reasonable explanation for their interpretation, and then said, you know, look, if the council wants us to do something different, they can pass explicit legislation telling us they want compound interest, not simple interest. Isn't that another way of looking at what they said?
But I don't actually believe they did that kind of analysis. I think they just simply said, it's been the firm position of the CRB since Maria Clark that we will only award simple interest. And if that's going to change, it has to be done through the DC Council. Well,
Are there cases where the CRB in between Clark and Harrison had in fact awarded compound interest?
No, it had been consistent in awarding simple interest. And it has to be remembered that this court in Riggs National Bank rejected the proposition that if a statute does not explicitly award interest, such an award is prohibited. So, and certainly the case in OHR v. DOC indicated that the ALJ had the authority to award interest and interpret an ambiguous statute as allowing for that award of interest.
So, Mr. Taylor, I'm not sure if I'm following. You're saying that what we should now interpret the statute to not preclude compound interest, sort of irrespective of Clark and Harrison? Is that your argument?
I think that this court could certainly find that today it is appropriate that compound interest be awarded for purposes of meeting the humanitarian act, the humanitarian basis of the CMPA.
We shouldn't. I guess the alternative, based on your argument, if I'm following you, would be remanding it back to the CRB to reinterpret Harrison. Is that what or clarify what they said in Harrison?
That's correct. If the court finds that they were wrong about having to have a statute to be able to award compound interest, and this court finds that the CRB had the authority to interpret the CMPA in light of the act's humanitarian purposes to award compound interest, then the court should remand it back for a panel decision as to whether compound interest is appropriate in these kind of cases.
Can I ask another question? I mean, that would seem like such a departure from what the CRB has already said and the practice that they've consistently followed since 2004. But I wonder, in your view, what impact, if any, does the Office of Risk Management's promulgation of 7 DCMR 161.3 in 2017? I mean, that seems to be consistent and further, at least, I don't know whether further indication that this notion of simple interest being the preferred route to go based on how our agencies are interpreting the statute.
7 DCMR 3361, now 7 DCMR 161, should be struck down as inconsistent with DC Code 283302 and Mitchell, and as an unreasonable interpretation of the act under OHR VDOC. Neither Mitchell nor 283302 say that, quote, interest may only be awarded where the program fails to make payment toward the compensation award within 12 months after the date of the compensation order, end of quote. That's quoting from 70 CMR 161. Nor is that consistent with the humanitarian and beneficent purposes of the CMPA. Neither Mitchell nor 283302 say that interest will, quote, be the lower of 4% per annum or the rate provided under DC Official Code 283302 C, again, quoting from 161. That regulation is not consistent with the humanitarian beneficent purposes of the CMPA or the remedial nature of 283302. So even though I appreciate that they introduced this regulation, it's clearly just in furtherance of ORM's risk management and has nothing to do with administering the CMPA in the manner it's meant to be administered, which is beneficent and humanitarian, and that
I mean,
should be awarded the full amount of their benefits.
with your time dwindling, I'm really curious to hear your last argument.
Thank you. I appreciate the prompt. I had lost track of my time. The argument is that the ALJ improperly failed to consider failed to calculate the scheduled award or the interest payments.
I think your argument is that DC Code 1623.24 entitles your client to ALJ and CRB review of that award, and that ORM, by promulgating rules purporting to cut off that type of review, was acting in abrogation of the statute. Is that right?
That's correct. There has also been a longstanding interpretation by the CRB that a scheduled award may be brought under 1-623.24 D1.
And that's Harrison as well, right?
D4 and Harrison.
Council, Harrison is decided and then these ORM regulations appear. Is there some sort of backstory, legislative history that we should be aware of?
Well, it was pretty clear that Harrison hit them with 7 years worth of interest. And again, consistent with ORM's attempt to
just spell that out for me a little. What do you mean 7 years worth of interest?
In Harrison, it took 7 years for the claimant to get his benefits. So interest was calculated on 7 years worth of benefits. I think that took ORM bit by surprise, and they decided we couldn't have that happening again. And so they issued these regulations. They tried all sort of things to bring in a statute of limitations, which they did.
I mean, it's a pretty
the
drastic.
7 years of back benefits kind of goes to the compound interest, but I think Judge Deal and I are particularly interested in this issue about divesting DOE's, ALJs, and CRBs, the CRB of review of these awards by kind of bifurcating these proceedings in a really awkward way. You know, you say that the ALJ can make the compensation award, but what the content of the award is, well, we don't know. We're going to send that over to our ORM. So can you talk to us a little bit more about the genesis of these regulations? Because, you know, it's hard for us to understand where they're coming from or why they exist.
You know, I can't answer why they came up with those regulations except to limit risk. What they essentially said was, we're going to prevent scheduled awards from being brought to ALJs. We are going to prevent ALJs and the CRB from ruling on anything other than entitlement, to say yay or nay to benefits, and the amount of the benefits, the period of the benefits, the rate of the benefits. All that's now going to be interpreted and decided on by ORM. And if you're not happy with it, your appeal is to the DC Superior Court. The result
But
of
in
that
your,
is,
sorry, go ahead, Judge Steele,
I
sorry.
mean, the specifics of this case aside, because it's kind of in a curious posture where there was already an ALJ and CRB decision before these regulations took effect. My understanding of DCPS's argument is that the entire claim, this claim in the future will just bypass the ALJ and DOES entirely, because in their view, it doesn't fit under 623.24 A or D. It's not a new claim. It's not a modification under their view. So putting calculation aside, the whole thing wouldn't get ALJ and CRB review. Is that right?
the way they are, their argument simply does say that scheduled awards will not come under review by ALJs or the CRB. And that is quite inconsistent with what they represented to this court in Shepherd v. District of Columbia, Department of Employment Services. In that case, and I will quote, the fact that petitioner's claim is not, quote, deemed accepted does not preclude recovery of her underlying claim for permanent partial disability benefits. The district advises us that a claim requesting modification of benefits like petitioner is in actual practice accorded the right to a full-scale hearing analogous to that described in DC Code 1-623.24b and to related appeals.
Well, I think what they're going to say is, well, that was true at the time. There was a regulation that entitled you to those hearings. Regulations have been changed. It was never a statutory right. I think that's going to be their response.
Right, but they can't pass regulations which are not in accord with the statute. And
Of course.
it's pretty clear that when you look at 1-623.24 D1 and 4, a scheduled award clearly should come under that because you have a change in condition. You have a person who previously was in a state of medical health where they might get better, they might get worse. They finally reached maximum medical improvement. They have stabilized. That's a change in their health status. They can bring a claim for scheduled award at that point. Furthermore, there's a change in the type of benefits being sought. They've gone from seeking benefits for temporary total or temporary partial to seeking benefits for permanent partial disability. And so you have a change in not only the employee's condition, but you have a change in the benefits being sought.
And remind me, what's DCPS's response to that? Right, I mean, I have a vague recollection that they said, oh, it's not a modification, but I can't remember why.
I must admit, I don't recall either.
So they have a broad answer and a narrow answer. So let me start with the narrow answer. The narrow answer in this case is, well, there's no modification because your temporary benefits had already expired, so there is no award remaining to modify. They dropped that at a footnote. Do you have a response to that?
There still is a modification in the nature of the benefits. There may be a time delay, but that's the very nature of a scheduled award. You have to reach maximum medical improvement. So you have a change in the benefits. I think all they're referring to there really is just a time delay. Again,
And I think their broader answer falls under D4, which is it has 5 subsections that delineate when the mayor can change an award. And we'll ask Ms. Van Zyl as well. But I think her answer is that D4 provides 5 circumstances in which the mayor can modify. And they're all circumstances where the person has gotten better. So they say it's not a modification under D4, so it doesn't fit under D because this isn't that circumstance. Harrison provides an answer to that, and I think it's your answer too, but I suppose I'll let you give it.
Well, section 1-62324D4 expressly prohibits a modification of a claimant's benefits unless a, quote, claimant's condition has changed from a total disability to a partial disability. Well, a partial disability is the exact touchstone of a scheduled award claim. That is what you are compensating, that permanent partial disability. So I would argue, certainly again, scheduled awards can come under 1-623.24D4 because you have a change in the claimant's condition going to from total disability to partial disability.
Is that right? This was at one point a total disability?
Kareem was temporarily totally disabled for
I
a
see.
period of time, correct.
Okay, I didn't realize that.
What's, Mr. Taylor, what is the impact? I mean, I understand that how these two sets of regulations comport with the statute, Office of Risk Management's new regulations and CRB's regulations. What is the impact, I guess, in Ms. Kareem's case? I mean, is it just a matter of whether she gets compound interest that would increase her award for permanent partial disability, or are there, I guess I see there's some bigger issues in play here about how these cases will proceed and whether it'll be on a bifurcated track, as Judge Easterly mentioned. But I'm trying to figure out, with respect to Ms. Kareem's case specifically, which has had an interesting procedural history here, what is the impact for her, depending on how we decide this issue?
Well, should you find that the scheduled award was not properly explained, DC is going to be coming back to her for $40,000. But the other impact, of course, is whether she gets compound interest or non-compound interest, which would result in a fair amount of money to her if it's compound interest. And then if one looks at the time period that was improperly used to compute the interest, she's owed like $700. But the greatest disadvantage to her was her inability to basically pursue all of her rights because her appeal became bifurcated, sending the issue of her entitlement up one track and the issue of her amount up a separate track to the Superior Court. And frankly, she just didn't want to go that route because she was exhausted from litigation, didn't want to incur the attorney's fees, and shouldn't have had to incur attorney's fees, shouldn't have had to even use an attorney in a workers' compensation claim. So she was not able to get all of her issues presented to this court by having them all decided by the ORM, having all those issues decided by the ALJ, having all those issues decided by the CRB, and then being able to present all the issues to this court. There are issues that got kicked out into the risk of having to appeal to the chief risk officer. And then if we were unhappy with that, to DC Superior Court. We didn't want to do that.
I was wondering, counsel, if there's some danger if we were to accept ORM's authority to calculate awards, whether there might be some attack subsequent to our decision on the actual award, like whether DCPS might go back to the CRB and say, vacate this affirmance. This never should have been with you. See what the Court of Appeals just did. This should have been taken to ORM.
I'm not sure what you're asking. Are you asking whether there would be retroactive effect if you were?
I mean, right now, DCPS seems to have conceded that the actual, award was properly issued by the DOE's ALJ and reviewed by the CRB. But my understanding is their position is not just that the calculation of the award should go to ORM, it's all of these permanent disability determinations should go to ORM. And so I'm wondering if, the logical conclusion of their argument in this case could be, hey, all of these proceedings are actually null and void. We haven't said that yet, but if we get a good decision from the Court of Appeals, we'll try to unwind all of this.
I mean, that certainly is quite possible. And why would they not do that? Particularly since there has been a large number of cases that were handled, scheduled award cases that went through the ORM, ALJ, CRB route, and they could well come back now and say, should never have gone that route. All of that should have been simply handled by ORM. So that is quite possible.
Mr. Taylor, we've taken you over your time with some of our questions on this issue, but we will reserve your time for rebuttal, and let's hear from Ms. Van Zyl.
Thank you, appreciate it.
Thank you.
Thank you, Your Honor. And we would submit that in light of Frazier in particular, and Webb as well, the only issue remaining to be resolved by this panel in the cross appeal is compound interest.
How do you figure with Frazier? I mean, because certainly when you look at Judge McLeese's dissent, his argument is none of these issues have been addressed. None of these issues have been addressed by the agency, and none of these issues have been addressed by the majority opinion. So I'm not quite sure how you rely on Frazier as binding precedent.
Well, I mean, the holding in Frazier was that schedule awards appropriately go from the program to the CRO rather than going.
I thought the holding had everything to do with retroactivity. And Judge McLeese says in his dissent, look, before you even talk about retroactivity, there's this thicket of statutes and regulations, and you'd have to figure out whether or not you think, he said, in trying to chart a path through this thicket, the natural first step would be to figure out what statutory provision, if any, authorized ORM to decide the merits of Ms. Frazier's claim for permanent partial disability benefits. Surprisingly, ORM, OAH, the CRB, and the opinion for the court all skipped that step. So given that, and I don't know that there's a response to that in the majority opinion, but if that's the case, I don't see how Frazier can be precedential authority for your position.
I mean, I think that Frazier is certainly directly on point in that it says that schedule awards are not part of the narrow class of determinations or adjudications that are dedicated to DOES by statute, right?
I hear you saying that. I'm asking a different question.
Well, so then the question is, if the statute itself does not say that schedule award determinations have to go.
No, the question has to do with what the kind of analysis Frazier does. And if Frazier didn't do that analysis, then how can we rely on it for the proposition that you'd like us to rely on it for?
Well, Judge McLeese says, what he seems to be searching for is affirmative statutory authority that says schedule awards should be determined by X actor, right? And what the majority said, I do think the majority responded to this.
I don't know that that's what he's saying. I think what he's saying is, look, we have this statute for the CMPA that if you read it start to finish, seems to contemplate this procedure where DOE's ALJs are going to make decisions about all manner of compensation awards, and compensation is defined quite broadly under the statute, and they're reviewed by the CRB. And this is how we have done it for a long time. And in fact, arguably the CMPA, the idea of the CMPA is baked into the Home Rule Act itself. And so now we have the executive in these regulations promulgated by ORM kind of carving out a whole chunk of awards from the jurisdiction of of the Department of Employment Services. And he's saying, where do they get the authority to do that? And who says so?
Well, so respectfully, I think that that's looking at it exactly backwards, right? What the court said in Frazier was, look, there are a narrow class of adjudications that are dedicated to go to DOES, and those are initial awards and modifications of awards in certain circumstances under 623.24. Other than that, the statute is silent as to where review of the program's determinations should go. And in fact, we know that some adjudications, the council specifically said, do not go to DOES and the CRB, right? Utilization review decisions do not go that route. And so the court in Frazier said we can properly infer that there is not this intent in the statute itself to send everything, absolutely everything, to DOES or now under the new regulations, OAH. What the statute says has to go to DOES are these determinations where a hearing would really matter, where credibility is important. So in initial award
And so
determinations—
you don't think that a determination of permanent partial disability is an instance where a hearing would really matter?
No,
I mean, I guess I take issue with sort of this understanding of the statute as sort of narrowly defining awards that go to the DOES, ALJ, and to CRB. It seems to me that the CMPA and the public sector workers part of it is quite broad in its coverage because of the humanitarian underpinnings of the act. And sure, utilization reviews go somewhere else, but compensation awards, either initial ones or modifications, unless somebody's actually getting better, as we discussed with Mr. Taylor, they go to the agency that is tasked with taking care of the district's workers, not to the Office of Risk Management. That's not their job. That's not the lens that they see decisions through.
Well, respectfully, Your Honor, the court in Frazier said otherwise. And with respect to the humanitarian purposes of the act, yes, I mean, substantively, the act is meant to give workers awards when they are injured on the job to replace their wages. But in terms of the procedural route you go to get there, the statute is only explicit in certain circumstances. And the mayor—
I've got two questions, and I'm sorry to interrupt, but Harrison disagrees with your interpretation of 623.24, and it says this would be considered a modification, right? So without citing to Frazier, we might disagree on what Frazier says. Could you explain to me why it would make sense for this type of compensation award to be removed from ALJ and CRB review while permitting initial claims of compensation and the small subset of what you will concede are modifications to get that type of review? What sense does that make? And while you answer that, I'll bake in my second question, which is, why do you say 623.06A doesn't apply here? Sorry, I'll come back to that if you can't remember that one. 623, never mind. Start with the first one.
So sure. Well, I'm happy to answer 06A. That's easy because Here we're not in a case where Ms. Kareem was bumping up against the 500-week limit. So you only come under, and Frazier talks about this as well, 623.06A, if you're at the 500-week, if you're approaching the 500-week cap, if you're within your last year. And so that wasn't the case here. Her award had already terminated. So we're definitely out of that portion of the statute. In terms of why it makes sense that this would not be a modification of an award. So first, I would note that when your temporary, total, or partial benefits are terminated, that is a modification of the award, right? And that generally needs to happen before or concurrent with you getting a schedule award. So at that point, you would be entitled to a hearing as to whether disability has ceased, whether you'd, in that context, the benefit should terminate because you've reached maximum medical improvement. So in that sense, I think you do get a hearing at some point. What you don't get a hearing on is the actual schedule award itself. And that makes sense because schedule awards are based on medical evidence, particularly under the Public Sector Act. And again, this was part of the logic of Frazier too, but I think the logic works independently. It's that these schedule awards are based generally on injuries that are intended to be conspicuous. The loss of an arm or a finger or a toe. Now it's a little more complicated, obviously, when you get into the issue of loss of use, but loss of use is generally, as you can see in the record in this case, if you're talking about partial loss of use, you're working with the reports of doctors. And I think it makes sense for the council to have not said in 623.07 that these are the kind of adjudications that have to get a full-blown hearing before an ALJ, because really
I'm utterly confused by this argument that it makes sense not to give them a hearing because this relies on reports of doctors. Because I think that describes every compensation claim. I mean, most, unless the injury is conceded. But as far as, you know, what I've seen in these compensation claims, the initial ones and the modifications, doctors' reports are, you know, they're everywhere. I mean, this is what the ALJs are looking at to figure out if this person is truly disabled, if it's causally related, how disabled they are. So I find that argument baffling.
To be sure, but Your Honor, you're looking at other things when you're talking about, for example, an initial award. You're looking at causation. By the time you get a schedule award, there's already going to be a history in the case, and those issues largely will have been decided. The kind of credibility contests over, well, what was the injury? Was it work related? You know,
that was here in this case, though, right? I mean, there was a question about whether her prior injury, whether or not they should diminish her award by, I think it was 5%, based on her prior rotator cuff surgery. I mean, that was still here. You know, it would.
Well, you know, Miss Van Zyl, I have to go back a little bit to Frazier. I mean, I know that there is a dissent in Frazier, but there is a majority opinion in Frazier, which says that the holding is that the regulatory scheme makes OAH review unavailable for the type of claim involved here. And because we're unpersuaded by petitioner's argument that this is unlawful, was unfairly retroactive, or denied her due process, we affirm. And I know that the dissent raised some questions about this, but I guess even if there may be some disagreement about the holding in Frazier, or concerns, which I happen to share based on some of the questions raised by my colleagues about why it makes sense to carve out the schedule awards for it to be decided and go a different track. How do we get around? I guess you need to talk a little bit more about why Frazier is binding in your view on this, on all the issues that are teed up here, because Frazier did deal with a case in a slightly different posture from our case. But I would find it difficult to get around the holding if it is applied as broadly as you're arguing it is. And so persuade us a little bit more on that, please.
Of course. I mean, and Frazier is binding. And I would note that there was a request for a hearing in bank that was denied in Frazier. And Frazier specifically adjudicated whether, you know, what we've been talking about, right? Whether schedule awards are properly reviewed by the CRO or by ALJs. So that question is answered. I mean, it doesn't even happen to be the question in this case, because in fact, because of the odd posture of this case, Ms. Karim did get a hearing on her schedule award in front of an ALJ. And so really what we're fighting about here, what she has standing to contest here, is just whether the calculation pursuant to that schedule award needs to also go to an ALJ. And the answer is clearly no. I mean, if this court has held that the statute does not require, or I think the court implied that the statute would not even permit schedule award controversies to go to ALJs. It certainly can't be the case that the schedule requires or
Well,
arguably even permits the calculation of those schedule awards
One,
to go to an
one
ALJ.
nuance that I want to ask you about is, having conceded in this case that this properly proceeded before the ALJ and the CRB as to the schedule award, whether or not you can make that, whether or not you can acquiesce to that jurisdiction while still in saying, but we get to peel off half of it and send it down another route. I mean, bifurcation is not envisioned under any scheme. That's something that's introduced into this litigation because of some odd litigation choices by DCPS. And because I know you did contest jurisdiction before the ALJ, but you lost that, and that was before the regulations. And I don't think you then contested it before the CRB, did you? Did you give up on that argument by then?
I believe at one stage it was raised before the CRB, but at this point, we view it as water under the bridge. I mean, she had her contested case hearing, and so as to the schedule award itself, for purposes of this case only, it happened. We are not trying to, we are not trying to and will not try to unwind it. What we're saying is that, per the default, the rules that were in effect at the time that a calculation would be needed should be applied. And those rules required the program to calculate and issue an award within 30 days of the ALJ making it.
Do you have any sort of legislative history for us on the promulgation of these rules? I mean, they seem to be responsive to Harrison and a rejection of Harrison, and they're passed on an emergency basis. And I'm kind of curious what the emergency was.
Of course. Well, I mean, the permanent rules were in effect by the time this case kind of resolved.
I understand.
And
what was the rush to get these rules in place?
Well, I think that the program realized that basically the current regulations were in tension with the statute. And so they undertook basically a wholesale reevaluation of the regulations governing the program. In part, I would say that there are two key reasons. One was to bring them into conformity with the statute. And the second was that there were just egregious delays in getting these cases resolved. I mean, this is talked about in the preamble to the 2017 regulations, which is referred to both in our brief and in Frazier. And the preamble explains that when these matters used to go before DOES ALJs, they would take almost a year from the time a hearing was held, not even accounting for the time pre-hearing, but from the time a hearing was held, it would take almost a year to get an award from the ALJ, and then you have further review by the CRB and potential further review by this court. And so that was troubling, particularly when it comes to something sort of ticky-tacky, like, something you can do with a calculator, like calculating an award. And so for things like that really are ministerial, the program said, and I think it said rightly, that it makes absolute sense for that to be done on a quick timeline by the program itself, timelines involving 30 days, 60 days, not a year, that still allow for appeal to the Superior Court and ultimately this court if that is in fact warranted. The other thing that I would note,
is there any sort of notice and comment, like, where claimants were saying, no, actually, we would like to go to the DOES ALJs and to the CRB and then straight to the Court of Appeals under the APA, right? Instead of being shunted to ORM, then having to initiate our own lawsuit, pay attorneys' fees for instituting a separate case in Superior Court and then appealing that to the Court of Appeals, if we have the energy for that. There
absolutely was notice and comment around the 2017 rules. And those comments were responded to in the register, and so that is available to the court to see how the program walked through and responded to these concerns. But the concerns that it found most troubling were the concerns about the lengthy delays here, the fact that litigants were going and seeking mandamus from this court because they simply weren't getting decisions in a timely manner from DOES, and the rules are intended to remedy that. And in that respect, I think they make sense. And one other thing that I would add in terms of the rules is that the way that compensation works is it's paid on a bi-weekly basis, right? It's not a lump sum. And so there are always going to be potential ongoing controversies with computation. It's not a one and done judgment in terms of the amount. And so given that, and given that the program will be administering those bi-weekly payments on a continuing basis, I think, if we're talking about whether it makes sense or not, I think it makes all the sense in the world to have the program that administers that and the experts who are able to move quickly resolving.
I don't take any issue with the administration of the payments, but the actual calculation of the payments in conjunction with the assessment of the award, that does seem to be something that more clearly falls under the statute as written. And I'm concerned that is a contested case, and that under the APA that is supposed to come directly, from the CRB to us, and that the ORM was purporting to divest, CRB and then this court of direct jurisdiction over that, which also would be problematic in my view.
Well, Your Honor, I think that is pretty squarely resolved by the majority, at least by implication or inference in Frazier. If schedule
Did they
awards
talk about
themselves-
the APA in Frazier?
Did they talk about the APA in Frazier? I mean, it was certainly in the background. I mean, as to whether this was a required contested case or not. And the statute certainly didn't give the right to a trial type hearing. The prior regulations did. They were repealed. In Frazier, the court said that was proper, that ORM had authority to do that. And without the regulations creating contested case jurisdiction, the proper place for these cases to go is to Superior Court. Now,
that's not entirely correct, right? I mean, yes, we look to see what is allowed under the statute as far as procedure to determine whether there's a contested case. But there are sort of constitutional due process concerns as well, right? So, I mean, it can't be completely circular that you can define the procedure to be so minimal such that it's not a contested case so that it doesn't go through the APA, right? And I can't remember, Judge Ruiz has an opinion where she discusses that and says, this court can look at a proceeding and say, a hearing is required here as a constitutional matter. And so therefore, it's a contested case, and this is the manner of review under the APA for contested cases.
Right. Well, I don't think anyone has argued here that there's a constitutional right to have an ALJ compute the dollars and cents of your award. And I think even in Frazier, the court said there's no due process problem with even taking the bigger item, the schedule award itself. There's no constitutional due process problem with having that reviewed by the CRO as opposed to the DOES ALJ. And I'm mindful of the fact that I don't think the clock has been running at all during my time, but I am mindful of the court's time. And again, I think the only issue here that isn't resolved squarely by Frazier is the issue of compound interest. And I would like to speak to that at least a bit in the sense that, I agree with what the members of this panel have said in terms of it being appropriate to defer to the CRB in terms of whether compound interest or simple interest is appropriate in adjudications under the Comprehensive Merit Personnel Act. And as Judge Deal commented, in Harrison, the CRB undertook a very careful, thoughtful analysis of the common law, of this court's precedents, of the absence of any legislative changes, and came to this very considered and thoughtful conclusion that it wanted to retain its rule that had been in place since at least 2004, that in workers' compensation matters, simple interest rather than compound interest is all that's available. And in making that determination, the CRB relied in part on the common law, which is and remains that prejudgment and judgment interest are not ordinarily compounded in the absence of a contractual provision or a statute. That's been the law in the District of Columbia since at least the Giant Foods case in 1979. It's drawn from Dobbs on remedies. If you look at the modern version of that treatise, it also says that the default rule is that interest runs on a simple basis. That is the majority rule among states. It is the universal rule among states in workers' compensation cases specifically. And it is the appropriate rule to keep. And now, of course, we also have an ORM regulation that says that interest should be awarded as simple rather than compound interest.
So I don't mean to drag you back. This will be the last thing I say, then I'll reply. When it comes to deference to the CRB, which you're urging that we provide on compound interest, did Frazier consider deference to the CRB on Harrison's other primary holding that these were that these schedule awards are modifications under 623.24D?
So
I mean, Frazier just jettisoned that part of Harrison without considering it, right? They didn't give CRB, which I think you would say we owe some deference to in interpreting the CMPA. They didn't give any consideration to the CRB's interpretation of its statute in that case.
Well, I mean, Harrison was certainly a part of that case, whether a citation worked its way into the opinion. I mean, I can tell you that the Harrison issues have been fiercely litigated and were certainly sort of mentioned in the proceedings in that case. Ultimately, what the court held was that this number one, the statute was clear. And number two, the ORM, which is also an expert agency in this space, had promulgated rules and that the ORM was accorded deference. And that was all the more true because in Frazier itself, because Frazier took place after the rules had been promulgated, the ALJ and the CRB said, look, there are rules, those rules govern here, and we will abide by them. And so I think that the court appropriately acted when it gave deference to ORM there. Now that may be a situation where you arguably, if you looked back at CRB precedent, had some conflict between two agencies that administer the CMPA workers' compensation provisions. Here on the issue of simple interest, there is no conflict, right? ORM and the CRB are in agreement. And so whoever you want to defer to, the answer would be that simple interest is appropriate. So I think that can be resolved by deference, looking at the fact that there's silence in the CMPA and allowing the agencies to interpret that silence. But even if you were to zoom out to look at the common law or to examine 283302B, the answer is the same. I mean, the cases say simple interest, nothing in that has changed. Certainly, federal cases are different because there is a federal statutory provision that provides for interest to be compounded on an annual basis. That's 28 USC section 1961. But there is no comparable statute. There's been no similar statutory change in the District of Columbia. So whether you...
Yes. I don't mean to interrupt you, but I take your argument there, and we have sort of taken you well over your time. Did you have any brief final remarks before I turn back to Mr. Taylor for his rebuttal?
Yes, just briefly, Your Honor. I did want to turn back to and have a small rebuttal on the 10% issue, which is just to say that in our conversations, there's been some conversation about whether it might have been appropriate for the ALJ to add the extra 10% because there was evidence in the record that might have supported that award. But this court will not affirm an agency's determination on grounds other than those supplied by the agency. And as this court said in Jones, when it determined that 7% in that case wasn't adequately explained, the court said, well, we can't say that there isn't substantial evidence in the record somewhere to support that conclusion, but we can't say what it is or how the ALJ considered it. And so I think that that would apply equally in this case. And on the Maryland 5 factors, just briefly, my friend representing Ms. Karim is correct. We're certainly not abandoning our argument that the Maryland 5 factors don't apply. It is an alternative argument in terms of why we think the court could reverse. The difference in the statutory language between the Private Sector Act and the Public Sector Act could not be clearer. The Maryland 5 factors appear in the Private Sector Act, not in the Public Sector Act. They were added to the Private Sector Act specifically in 1998 to conform the Private Sector Act with Maryland law. At the same time, they were not added to the public sector statute. And in fact, since then—
I'm sorry to drag you over, but it's a yes or no. Was that raised below? Did you guys make that argument below?
We did not.
Okay, thank you. Let's turn back to Mr. Taylor for a rebuttal, please.
Thank you, Your Honor. I'd first like to address Frazier. And I think that's important to recognize that Frazier dealt with the specific and sole issue of whether the Office of Administrative Hearings, the Mayor's Office of Administrative Hearings, had jurisdiction to hear a scheduled award claim, particularly since counsel appeared to have made a mistake and filed his request for a hearing under 1-623. I think it's 06 or 08, I don't recall. But the court in Frazier's, and the only ruling that it was faced with, the only ruling it had to make was that the Office of Administrative Hearings did not have jurisdiction. Now, that all the rest of it is all just dicta. And that dicta, in the context of a public sector case, the court indicated, well, that dicta is at odds with Dent, Taguchi, and Larry Barron, does not accord deference due to the CRB's interpretation of 1-623.07 in Larry Barron, and in this case, runs afoul of DC Code 1-623.02A, and Judge McLeese is correct that a more thorough analysis, had it been done, I think those would have been the conclusions. Certainly, the court did not directly address ORM's authority to vest DC Superior Court with jurisdiction to hear appeals of scheduled award claims. Now, Ms. Van Zyl indicated that the fact that there is one indication where the DC Council had utilization reviews being reviewed by the DC Superior Court is an indication that such reviews could occur in all different manner of subject areas dealt with by ORM. But here you have the old Latin phrase, and I won't mangle it, but it's the old, expression of one excludes others. The DC Council, if it had wanted all of this other stuff to be reviewed by DC Superior Court, could have said so. They didn't. The only place they gave authority to have matters relating to workers' comp viewed by DC Superior Court was for utilization reviews. They could have said otherwise. They didn't. Most importantly, I think this court needs to be very careful because it's going to get an absolute onslaught of issues coming through DC Superior Court up to this court, while at the same time, it's going to be getting the same cases coming up a different tract through the ALJ, CRB, and DC Court of Appeals tract. Because one, you've got entitlement issues being resolved, and then you've got rate, period, and amount issues being resolved in two separate forums, taking two separate tracks of appeal. And I think the court, whatever it does, has got to do something to prevent that from happening just for your own calendar and for your own work. It obviously is very important for there to be a hearing in a scheduled award claim, particularly since there is a whole host of cases that have indicated that the District of Columbia is an industrial loss of use jurisdiction, loss of function use jurisdiction. And in that situation, it's important for there to be testimony from a claimant as to the pain they suffer, the inability to do certain things that are related to their work. And so a hearing is certainly necessary in that kind of a case. It is not just a medical claim. This court in Degussy indicated that claims for compensation are not merely compensation for a medical injury, but rather are compensation for a loss of an ability to earn income. And to have that kind of analysis requires a hearing.
I'm sorry, Mr. Taylor, I didn't mean to interrupt you.
Go ahead.
No, I didn't mean to interrupt you. Were you getting ready to make your final responses and remarks?
With respect to interest, yes. With respect to interest, I actually don't care whether it's an evaluation and an interpretation by the CRB, or it is a regulation by the ORM. Both of those have to be consistent with the humanitarian and beneficent purposes of the CMPA. The CMPA is meant to give a full measure of compensation to make up for lost wages. If a claimant does not receive compound interest, they in fact are not receiving that. And so any interpretation by either the CRB or by ORM and regulation that says that interest is not compound is simply not in line with the humanitarian purposes of the Act. And this court in a number of cases has said that when that is true, it will not uphold regulations that are not in accord with the remedial and humanitarian nature of the Act. With respect to the, I actually think that's probably enough.
All right, thank you. I'd like to thank both counsel for your briefs and arguments in this case, and the case is submitted and taken under advisement. Thank you both for your arguments today.
Thank you, Your Honors.
Thank you, Your Honor.
Bringing in the next case, Judge.
All right, thank you. Good morning. Our second case this morning is Stephen Jones versus United States. Are the parties ready to proceed?
Yes, Your Honor.
Can I take one very brief pause because I'm experiencing some background noise on my end. If you give me 1 second, see if I can adjust it. Okay, my apologies. Okay, counsel, are you ready to proceed?
Yes, Your Honor, we are ready to proceed.
All right, Ms. Harden.
Thank you, Your Honor. Good morning. May it please the court. Brandy Harden, counsel on behalf of appellant Stephen Jones. Today, I'd like to reserve 3 minutes of my time for rebuttal. In Sell versus United States, the Supreme Court recognized that a defendant has a significant liberty interest in avoiding the
Ms. Harden,
Yes.
I'm sorry to interrupt so soon, but we have a number of questions about what the current state of affairs are with the case that might be helpful, at least for me, in putting it in context with some of the legal arguments that you're getting ready to make about Sell.
Yes, Your Honor.
Has Mr. Jones been deemed to be competent? Is there a pending court hearing date in Superior Court? Is he being forcefully medicated at this time or voluntarily taking his medication? I guess to the extent that you know, could you just give us an update on some of the current facts and posture of the case, please?
Yes, Your Honor. There is a pending status hearing. Mr. Jones is being forcibly medicated. He has been deemed competent as of May 22nd of 2020. And we do have a hearing upcoming in November before the trial court on actually asking that court to also vacate the order that's pending, or the order that the court has before it at this time. So there
is that hearing to rule on his, Mr. Jones's motion to withdraw his guilty plea, or is that hearing to determine whether to redetermine competency? Do you know what the scope or purpose of that hearing is?
Yes, Your Honor. It's actually to have him decide whether to proceed to sentencing. But I did make 2 oral requests that the court vacate the order after he was deemed competent. My position at that time was that the forcible medication order only stood as long as it took to get him competent, and therefore the court should not continue to forcibly medicate him once he had been deemed competent. I made that request both in front of one judge and then in front of the trial judge. The court has asked us to brief that issue. We intend to do that, and we are back before the court on, I believe, November the 19th.
So should this appeal be held in abeyance pending that? I mean, because that could possibly moot all of this out, correct?
Your Honor, it could moot it all out, assuming that the court were to agree that the court should vacate the order. I don't believe, though, that the court should be held.
The trial court wouldn't have, to be clear, right? The trial court wouldn't have the immediate authority. We'd have to go through the Smith v. Pollen procedure to get an advisory ruling from the trial court as to whether or not the forcible medication order that's on appeal to us should be vacated. And then, we could then remand back to her so she could vacate the order if that were her determination. And I guess if she were to uphold it, then we'd know that the case wasn't moot. Although if your client then decides to go to sentencing, then that also sort of creates a mootness question in my mind too, right?
Yes, and I understand that that the court could obviously put us in a situation where the court holds this in abeyance until the court has jurisdiction again to rehear the issue. But I do think that this falls within the exception to the mootness doctrine, and it's capable of repetition yet evading review. And so I don't think that the court should hold this in abeyance and go back before the trial court, because I believe that our arguments here are that there are some deficiencies to the ruling that was made by the trial court, and that court is likely to uphold the ruling based on the testimony that she heard over the 3 days of testimony.
Can you just point me to where the order is in the record or the appendix? Is it just the oral ruling, the transcript that you have?
Yes, Your Honor. Yes, Your Honor. That is the order that the court issued, and that ruling that I put in the appendix is the order that the court gave.
So is there something that says it lasts in perpetuity?
So that is one of my positions. It doesn't say that it lasts into perpetuity. It just lacks any specificity as it relates to how long this would be going on, which is why when I got back before the trial court at the first hearing, sort of post-pandemic, I made the oral request to have, again, at that time, the court had before it an order, a report indicating that Mr. Jones had been found competent. And so I made that immediate request to vacate the order. So
that's the July 6th. Is that the
dates?
July 6th order, Ms. Harden?
Brief indulgence, Your Honor.
Or about thereabouts, July?
So no, Your Honor, it's February 12th
February 12th.
2020 that the court
Right, but
issued the-
I'm sorry to interrupt. I just want to make sure we're talking in dates because it gets sort of confusing which order and which court we're talking about. So there is an oral ruling from the Superior Court in February of this year saying, yes, forcible medication can be administered, right? And then subsequent to that, and that stayed for some limited amount of time.
That's correct, Your Honor.
And then the stay lifts. And then there's a medical, from what I understand, just looking at court view and, for everyone's benefit, we have looked at court view, as I think we're authorized to do. It looks from court view like there was a medical report filed with the trial judge in May of this year saying we, as a medical determination, think that Mr. Jones is competent. And then I understand that there is a judicial determination of competence in July. And then I see there's something in August indicating that a status hearing is scheduled and that pleadings should be filed in September. And so I take it that your position, that has there been any challenge to the judicial determination of competence? What I understand you to say is, no, you accept the judicial determination of competence from July, and it's on that basis that you are now asking for consideration of the forcible medication order from February because there's no need for it anymore if he is competent. Is that correct?
That is correct, Your Honor, and I have not made an additional challenge to the trial court in that way. When we were before the court, I did ask that the court vacate the order based on the fact that he was competent. At that time, because of the pandemic, I was not in front of the calendar judge. We quickly scheduled a status hearing in front of the calendar judge. I then did make that request, and as the court has indicated, those briefs are forthcoming.
Is he
Okay, so they actually have
experiencing
been
any side effects from the medication that's being continuing to be forcibly administered to him?
I'm sorry, I just didn't hear the court. Did the court ask me about side effects?
Yes, he's being forcibly medicated with the injection of the risperidol.
That's correct.
And that's continued and been ongoing. Is he experiencing any side effects, adverse side effects to that you are aware of?
He is, Your Honor, and I maintain the representations that I did in my brief that he is still experiencing incontinence. He is still experiencing tremors. He's experiencing some grogginess. And so he is absolutely still experiencing the side effects as it relates to this involuntary medication.
Just to go back to my procedural questions, the court view docket indicates that pleadings were scheduled to be filed in September, but what I hear you saying is that the briefing is not yet complete.
That's correct, Your Honor. That is correct.
Okay.
Those briefings, that is correct. They are not complete at this time, but they are scheduled to be done and heard at the, I believe, November 19th hearing.
Okay. Thank you. So you were talking to us on the merits about SEL, and I guess one question that I had was both the government and Mr. Jones seem to couch their arguments in SEL, but correct me if I'm wrong. I mean, we have a statute now that essentially was responsive to SEL and said, this is when you can forcibly medicate in the district. And so what I understand really is that Mr. Jones has sort of a statutory sufficiency claim under DC code, 24-53109. Is that correct? Or is there a separate constitutional claim? I understand his constitutional concerns to collapse into or to be satisfied by the protections afforded under the statute. Or are you saying that the statute is insufficiently protective of his interests?
Your Honor, it's not my argument that the statute is insufficiently protective of his interests. It's just that I have a broader argument in that due process was violated, particularly here, because the protections that is the government was supposed to meet their burden by clear and convincing evidence did not happen at the time that the court heard the testimony and entered the forcible medication order. I think that DC Code 2453109 is consistent with the requirements in cell, and I think that under the cell analysis, the government has just failed to meet their burden with respect to 3 of those 4 factors.
Ms. Harden, can I take you back to my one of my questions just about, you were talking about the side effects, which is part of your argument as to why the government didn't meet its burden by clear and convincing evidence. As I understand your argument, is there are a couple of points. One, he's having side effects, Mr. Jones, from the forcible medication. 2, the medical need for the medication and medical protocols were not sufficiently set forth in terms of how long he would need to be medicated. And then the other argument is that other less restrictive precautions or attempts weren't made. And I'm gonna just take them in the reverse. On the less restrictive precautions, there were attempts to administer 2 other kinds of medications, the Lozapine, the pill, and then the Risperdal, the dissolvable pill. But for both of those, it was deemed that Mr. Jones was not appropriately taking them, cheeking them, spitting them out, other things, which is why the injection came about. So I think that argument, I'm not sure I find fully persuasive unless I'm missing something on that one.
So, Your Honor, if I may, with respect to the 2 types of medication that St. Elizabeth's put in place for Mr. Jones, the issue comes down to, at some point, even based on what the court has deemed as sort of sporadic taking of both of those medications, Mr. Jones was actually deemed competent. So even though there was a minimal taking of the medication, St. Elizabeth's at one point during that sporadic period of time deemed him competent. And so
but then he decompensated significantly from what the doctors say following that, which is what they argue necessitated the need for the forcible medication.
And I think the issue comes before Your Honor as at the time that Mr. Jones was deemed competent, the court nor the government provided any evidence of what those levels were, right? The court didn't know, the government didn't establish anything about what those blood levels were that allowed him to remain competent. And so having him take the subsequent medication may or may not have met what would have been necessary in terms of the amount of medication which would have rendered him competent. So
yeah, but now we know he is competent based on the medications that he's been taking. So is that argument mooted out?
No, Your Honor, because respectfully, Mr. Jones' argument is not whether or not the end result is competence. It's whether the steps that were taken to get the trial court to allowing him to be forcibly medicated, whether those protections were properly evaluated under due process. And so it's about the steps. How did
where in the, I'm sorry, Ms. Harden, where in the process on the timeline was he, remind me of the dates when he was momentarily deemed competent, even with the sporadic medication,
yes,
before he decompensated again?
Yes, Your Honor, that was in February of 2019.
19, okay.
And
How
so
long did that condition last? Does the record reflect that?
It's approximately 3 months, but I can't say to the court, and I think that's one of the problems here. I can't say to the court exactly how long it lasted. One, because there was not an individualized medication plan that was ever submitted. The following DBH report, however, did indicate that he was now back incompetent after that brief period of time where he was competent. And there's some information that he did take some medication in the intervening months, but in fact, he was experiencing these side effects and did not continue to take the medication as regularly as they would have requested or liked at that time.
Is there any reason why during that brief period of competence in February 2019, I guess he wasn't deemed competent enough to proceed with the court proceedings? Is that what the issue was? He was more competent than he was when he was incompetent, but he was only temporarily competent, but not competent enough to go forward with any court proceedings.
So he was competent to proceed with the court proceeding. And I do want to take the court back to sort of the facts here are that the only issue that was before the court, because as the court can see from the DBH reports, Mr. Jones remained having an excellent factual understanding of the legal proceedings. That was never the question. The only question was whether or not the delusions were so pronounced that they would interfere with his ability to assist counsel. And so when he was deemed competent, not only did the Department of Behavioral Health say in their report, we are determining him competent to proceed to sentencing. We were prepared to do that. We then set a next hearing, and the next report that came said that Mr. Jones was in fact incompetent, and therefore we were back to square one. The government then made additional requests and at some point made a request to involuntarily medicate Mr. Jones.
Okay. And then on your argument on the, on the scope of why the government failed to meet its burden on the scope of the medication, is that based on the fact that there was no determination as to how long he might need to be forcibly medicated to obtain competence and I guess maintain it for the purposes of any court proceedings?
Yes, Your Honor, that is one problem, one defect in terms of the trial court's order. But more importantly, the problem with just saying, the government saying and the court accepting 25 milligrams of risperidone will work is that there's no dosage range. There's no ability for St. Elizabeth's to say we would start at this amount and we may end up at this amount. And there's no information about how they would regulate any side effects or any mitigate anything that may happen as a result of the dosage of drugs.
Can you unpack that a little bit for me? I mean, is your argument that I don't think that your argument is that you want judges to be prescribing doses.
No, not micromanaging
I hope
that
not.
way.
Good, because I don't feel qualified to do that. But I take it that your argument is that evidence should have been presented to the court about the dosing so that the court could review the dosage proposals. But then I sort of slide into my first point, which is why would judges be really good at that either? So
one of the things, Your Honor, I don't think that the court should be responsible or required for micromanaging the medication. The issue really comes down to whether or not the court has enough information, however, to make a reasonable determination that in fact, that the medication or the administration of the medication is substantially likely to render the defendant competent. So no, the court doesn't have to look into micromanaging the amounts, but where you have a period where a defendant has been found competent and you are unaware of what it took, that is the amount of medication that it took to render him competent, just getting a 25 milligram biweekly injection assessment from DBH doesn't put you in a position of knowing what it actually takes to make him competent. And therefore, the analysis of whether this medication is likely to render him competent, you can't really make. It's just a blanket assertion that 25 milligrams.
Say you had a situation, sorry to interrupt you, but say you had a situation where he had not been found competent and just, it's the same progression over, I think that these proceedings have lasted a year and a half, maybe we're up to 2 years at this point. And so they're trying other things, they're trying other medications, they're trying to get him to voluntarily take meds, and nothing is working. But what they do have is, some data that indicates that this type of medication is good for these targeted delusions. And they have some data about if you are an adult male who weighs about this much, this is the kind of baseline low dose that you should take. Like, why wouldn't that be sufficient? Why do we have to have this kind of targeted, assessment?
So, Your Honor, if I understand the court correctly, the court is asking me sort of a hypothetical about what would happen if Mr. Jones had not been found competent. There was this previous
Correct.
period of competency. And so I think that what the court still would have been required to do is know why 25 milligrams versus 12.5 versus some other lower dosage would, again, get Mr. Jones in a position of being competent. I think it's very
Right,
different.
but is the information that I'm giving you of, look, this is medically indicated for this condition. We have some information that it is effective, and that, we have these kind of dosing requirements based on, gender and weight and age. And, this is kind of how we, maybe I'm just thinking about, when my children go to the pediatrician and they say, how much does your kid weigh? Okay, they can take this much ibuprofen, right? But like, I assume that there's some sort of calculation like that. And why isn't it enough for them to say this is kind of the baseline dose for someone of his age and his, weight and, condition? We'll start here and then we'll see if that works.
So, Your Honor, it's Mr. Jones' position that it's still just insufficient, and that's because in United States versus Bush, the court indicated that the government must show a treatment plan that not works only in general, which is what I think I hear the court saying. Generally, if you weigh this much, if you're a male, if you're in this circumstance, this is a medication that's likely to work. That is not what Bush said. It said specifically that the treatment plan must establish that it is likely to work on this defendant in particular. And I think that I not only argued that in my briefs, I think here it's very important for the court to understand the factual basis here. Mr. Jones was not someone who was unable to understand the factual legal situation. And so, again, the only thing they would be addressing is not sort of generally, right, whether you fit the bill for male who is this amount, who weighs this amount, and then you would be able to take this amount of medication. This is a pretty fine line on whether or not the delusions, which the doctors opined are not going to go away, it's just whether they're less pronounced. And so that may have put Mr. Jones in a situation where a very minimal amount of medication would be required to make him competent. And therefore,
did the doctors say, did they say that the delusions are not going to go away full stop? Or that you can't medicate out of the delusional state, that the idea is that we're going to medicate him enough such that he is then amenable to cognitive behavioral therapy. And so that it's a 1-2 punch, to try and get to address the situation, right? Like the delusions are so tenacious at this point that he can't even start kind of doing the CBT to kind of address them. That's what I thought that they were suggesting as the course of treatment.
Well, yeah, that is correct, Your Honor. They were sort of suggesting that, except with respect to the reduction of the intensity of the delusions, the doctor specifically opined that it was unnecessary for the symptoms to disappear completely to restore him to competence. Instead, they argued it would be sufficient to just reduce the intensity of the delusions. And so the question that the court needed to resolve is, at what level of medication do the delusions resolve themselves sufficient for him to proceed to sentencing or decide whether to withdraw his guilty plea? And a blanket sort of 25 milligrams will work in general because other patients, the study that they relied on was small in nature, 37 patients in total. To talk about it generally doesn't do what Bush requires. It doesn't do an individualized analysis of what would have been required here.
Well, I'm not so sure that it was so general, Ms. Harden, as I understand it, and I may not be clear on this, but they said no more than 25 milligrams. And did they immediately start him at 25 milligrams?
They did. And that's my understanding. I can be corrected on that. And I did.
But he's also doing other things. He's doing therapy in conjunction with that, or at least he was.
And I don't have the information for the court on whether he continues in the
To do
therapy.
that.
What I do know is that I don't believe it's correct that they said up to 25 milligrams. I believe what they said was this is the dosage that we're going to give him. And they did start him on 25 milligrams. And I don't know that.
Just so I can get some statutory mooring here, is your argument that when subsection D refers to any less intrusive treatment alternatives, a lower dosage you would describe as a less intrusive, even if a forcible medication of a lower dosage is a less intrusive treatment alternative?
No, Your Honor, I'm sorry. That's
Okay.
not my argument.
Okay,
You're in the fourth prong, aren't you, of the statute? That what is the medical basis, or are we all missing which prong your argument is?
Yeah, which prong are you? What prong does dosage fall underneath that the court needs to?
So dosage deals with the second portion, Your Honor, whether the involuntary medication will significantly further the government's interests and whether the administration of the drugs is substantially likely to render the defendant competent. So I'm really in 2 and potentially in 4.
Well, the fact that something less might do it doesn't change that something more would do it. So that's why I wonder if you're really in 4 and you're trying to say that. So I'm just losing. I'm losing at what point Sell or the statute says, courts should be micromanaging the precise dosage of medication, as opposed to saying, well, if the medication is necessary, you go through the 5 factors and you say, okay, all well and good. Dosage, we're going to leave that up to the medical professionals. Within some range. You don't get to go to a dangerous point, but we're not going to say you have to do the fewest milligrams that could substantially be likely to restore them to competency. I'm just trying to understand how this plays with the statute.
So, Your Honor, with respect to less intrusive means, that's the third factor in the statute. It's our position that DBH nor the government provided any basis for the court to determine that CBT would actually not work. Yes, there was some discussion that Mr. Jones had participated in CBT, that it had somehow, in some ways, not worked. However, at the time that the court ordered the involuntary medication, Mr. Jones was not significantly participating in CBT. And even though Dr. Mazzotta and Dr. Sequeira says that it's something that CBT causes the defendant to have to look into insight into himself in order to address the delusions, the court did not have, nor did the government provide any basis on which to say CBT would in fact not work. Again, I
thought the doctor said he's too delusional for CBT to work.
Well, they did say that, Your Honor, as a conclusion. There, in fact, though, was no supporting documentation provided to the court about what failed, what worked, what did happen, what didn't happen, because there were.
Did you get a chance to ask the doctor those questions?
I did, Your Honor, and I think consistent with what the court is saying, the doctors both said that his delusions were too pronounced to allow him to participate in CBT. It was something that I was requesting, not only that the court sort of wait in terms of the voluntary medication order to do. I was asking that the court allow him to get further into CBT, and I think that the court credited the testimony of Dr. Sequeira and Dr. Mazzotta that his delusions were too severe. The issue, though, is that it had not taken on, he had not been involved in it for any period of time sufficient for the court to make that determination. A blanket assertion from the doctors that, oh, well, he's somebody whose delusions are just too severe to undergo CBT is not the kind of recommendation that the court should just adopt. The court should have further information about.
Right, Ms. Harden, I don't mean to interrupt you mid-sentence, but I think take that point, and I want to make sure that you've had a chance to wrap up your overall argument so that we can hear from Mr. Coleman, because I know our questions have taken you well over your time.
Very well, Your Honor. So I would like to just say, if the prior efficacy was the basis on which the government was relying to determine future efficacy of the medicine, then in order to meet their burden, they needed to provide the court with the risperidone levels and dosage from the treating psychiatrist when it was found competent to juxtapose against the propriety of the 25 milligram injection. I think I've already said that Mr. Jones had an excellent factual legal understanding. And again, what was important here,
He was pretty delusional, Miss Harden, and I think that was sort of the real critical concern here, that he was still threatening to finish the job of actually ensuring that the complaining witness was dead, the one that he tried to shoot and kill, and his delusions. I don't know what the current medical records say now that he's been forcibly medicated, but his delusions were intensifying in that regard. And that was really at the crux and heart of the concern for the trial judge here.
I do think that is correct, Your Honor. I think, though, that the issue comes down or before the court is that, but there was a period of time where the medication that Mr. Jones took rendered him competent. And the only issue that the court was resolving, since the doctors had opined that these delusions were not going to go away. I mean, I think that's one thing that's factually different here from a lot of cases. I mean, the doctors were saying, all we want to do is just back these delusions up some. He's still going to be talking about them, but we just want them to reduce themselves in intensity. And so then we're talking about, certainly Mr. Jones' position, a very small portion of medication that would have gotten him back to when he was found competent while he was taking this sporadic amount of medication. And I think that's what's different here, is that the doctors were only looking to resolve the delusions in their intensity. Your Honor, I will reserve my additional time that I have. I've asked for additional 3 minutes to respond.
We'll definitely give you your rebuttal time, Ms. Harden.
Very well.
Thank you.
Your Honor, I think at this time, just if I can just say one more thing, at this time, I would just ask the court to vacate the trial court's order.
Thank you. Mr. Coleman?
Good morning. May it please the court. Nick Coleman for the United States. I'd like to begin by addressing what I think is sort of something of a new argument that I'm hearing from appellant today, which is that it's the amount of dosage. In other words, that appellant didn't object to involuntary medication but it should have been at a lower dosage. First, I'm not sure that really was an argument that has been presented before today. And even if it had been, I think it, again, calls for too much specificity from medical professionals who are trying to figure out exactly what kind of a treatment or dosage level is going to be effective with a particular patient. In particular,
that may be so, but I thought that Ms. Harden was actually making a additional argument of, look, if even when he's cheeking the medication, he's getting enough such that he can become competent, then we don't need to forcibly medicate him. I thought that was the nature of the argument.
And maybe that's the argument that's being made. I think the record does not support that argument, certainly not in this case. So there was a period of about exactly 1 month in which the doctors at St. Elizabeth's opined that appellant was competent. And that was between an early February report and then a early March report. And
can I just ask, sorry, this is a very detailed fact question, but you say there's a month of time. Presumably it's not like a daily check-in, like, is he competent today? How's he doing today? How's he doing the next day, right? Like, do we know kind of how there's one report and then presumably some gap of time, or can you just clarify for me? It's just, I'm not clear on it.
So specifically what happened was in early February of 2019, the doctors send a report saying, we think appellant is now competent to proceed to sentencing. They indicate that he has been sporadically taking risperidone. They are concerned that he is cheeking, that he's sometimes spitting it out. So they did find that his blood levels showed lower amounts of risperidone than they thought were going to be available, but he did seem to be improving. Part of the problem and the reason why the trial court asked for clarification was that at the time there were two options for which way the case was going to go. There was still a pending motion to withdraw appellant's guilty plea, and the report from the doctors indicated only that he was competent to proceed to sentencing. And so the government in particular was concerned that it wasn't clear that they were saying, did they think that there was a difference between withdrawing a guilty plea or proceeding to sentencing? And so the court asked for clarification. The very next report, which I think is on March 4th, indicates that he's back to incompetent, and that he had discontinued his therapy, and that he had told his individual therapist, "I'm just not taking the medication at all. I'm spitting it out."
Would the doctors be able to opine on that sort of discrepancy? Yes, competent to go to sentencing, no, competent to withdraw a guilty plea? Or would they kind of give a general competency evaluation and then the trial court? It seems kind of like a legal question to me. It would be peculiar if doctors opined on that.
I agree, but again, we can only take the reports as they're given to us from the Department of Behavioral Health. For example, the most recent report, the May 2020 report, which I think is included as document E in appellant's appendix, that's the one that finds him competent now. They say that he's competent to proceed to sentencing, and I think also to consider whether or not to withdraw his plea. Exactly why they're drawing a potential distinction, I just don't know. I would agree with you that I think that really what you want is just, is he competent to, participate in his defense, which would include either going to trial or going to sentencing, et cetera. Whether there's a difference, I think, is not really presented in this case.
I know Ms. Harden answered this question, but I just want to make sure you agree. And also I want a reminder because I forget a little bit. What's on the table at this November hearing that's coming up?
So my understanding is that, yes, the court wanted to hear from the defense as to whether or not it was no longer necessary to involuntarily medicate appellant because he achieved competence. And I think the court wanted to get some briefing about that. So the defense was expected to file a pleading. I think that was scheduled for September, and then the government was going to file its response about a week later. Obviously,
why aren't they just proceeding to sentencing then?
So my understanding is that appellant does not want to be sentenced via WebEx. Right now, the problem is whether or not he can be sentenced in person in court. And because of the coronavirus restrictions, there are still difficulties in scheduling in-person hearings in Superior Court. So my understanding, and I could be wrong about that, is that is why this case is still in a holding pattern. It hasn't proceeded to sentencing yet.
What's happened to the motion to withdraw the guilty plea? Has that motion been withdrawn, or has it been ruled on?
I'd have to defer to Ms. Harden, who probably has the most specific information. My understanding is that appellant has informed the court through counsel that he no longer seeks to withdraw his guilty plea. Obviously, I don't know whether that has changed or whether that is likely to change. But my understanding now is certainly that at this point, the doctors have opined and the court found back in July, appellant is competent to make that decision, and he is competent to proceed to sentencing. And we're basically just waiting to sentence him. I think he could be remotely sentenced, via WebEx if he would consent to that. But my understanding is that since he has not consented to that, it's being deferred until such a time as he can be brought to court.
So Mr. Coleman, in the government's view, what's the efficacy of proceeding at this juncture with the appeal? This appeal?
Well, so it's not, my understanding of what the doctors have said and of the entire course of this case is that if medication stops, appellant is likely to become incompetent again. He has been medicated now. He is now competent. And, it's the government's position that he should, stay competent so that we can get this case resolved. We definitely think that this court, certainly should not vacate the involuntary medication order because that is what is making sure that he stays medicated. I did see in the May 2020 report from DBH that he is, it appears that he's been receiving injections. It appears he has also been voluntarily taking some sort of oral dose of risperidone. Again, since that report hasn't been, fleshed out on the record, certainly something before this court, I don't know precisely how that's working. But certainly, I think there's every indication that without the order, he will stop taking the medication, and it is likely that his delusions will again sort of take over and become too severe for him to be competent. So, we would respectfully submit that the order, when it was entered in February, was valid. It was fully supported. It can be affirmed on that basis. If appellant wants to continue asking the Superior Court judge to vacate it, he can do so. And then, if there's an order denying his motion, he can then, sort of review his options to potentially appeal that decision. But we certainly don't think that at this point, there is any need to vacate the order on the basis of a motion below that hasn't been.
And is your understanding that this order runs in perpetuity?
So I don't know that it runs in perpetuity. I think what happens is it was designed to sort of maintain his competence. The court did ask for updates. I think, again, the coronavirus sort of upended that. But the court did ask for an update after it entered the order. And then when it lifted the stay back in March, it directed DBH to file a report by, I think, March 20th, which I think it did. And then there was supposed to be a status hearing on March 26th. That got scrambled. There has since been the May report. I think, there's no indication that the court was just saying, we'll keep doing this forever. But I think there was an expectation that he would probably remain medicated until the case could go to sentencing, unless the doctors said it's not necessary, or if appellant could show that it was not necessary.
So, no, I don't. I mean, you tell me what the record says, but did anybody at the hearing envision the dosage continuing on this long? And let's assume there's not going to be an in-person sentencing for another 6 months. Did anybody opine on whether or not the duration of this medication?
I don't think that there. I don't recall any specific testimony on that point. Again, I think when you look at DBH's reports and the testimony at the hearing, it's not entirely clear, and I think it's hard to predict in a case like this where you're dealing with a very rare disorder like delusional disorder, as to whether some initial medication, then combining it with some sort of therapy might cause his symptoms to abate over time to the point where maybe he wouldn't need it. I don't know. I think the expectation was that this case, assuming he did not withdraw his guilty plea, it would proceed to sentencing. I think this case would probably be over by now, were it not for the fact that, because of the pandemic, we've had to put things on hold.
So I thought that there was testimony by one of the experts that they were anticipating that there would be improvement in 2 to 3 months with the medication and competency within 4 to 5 months.
Yes,
So
that's correct.
So if we start in March, when the stay is lifted, that's April, May, June, July, August. I mean, he's actually quickly determined competent in May by the doctors, and then a judicial determination of competence in July. So I guess in light of that testimony, was the court's order deficient in not having an end point? I mean, I think you've said, look, nobody thought that this was going to go on this long. We thought that he was going to go to sentencing, and then, the world blew up. But, it does seem like it is on its face pretty open-ended.
So I think, that expectation was, that was the prediction for improvement and then achieving competence. In terms of how to maintain him in competence, I don't think the idea was just like, it's not like administering an antibiotic. It gets rid of the, of the bacteria, and now everybody's done and you don't have to keep taking it. I don't know that there was, in fact, an indication that after 4 to 5 months, it would no longer be necessary. In fact, appellant's prior experience of sort of, briefly attaining competence, but then regressing once he really just stopped taking the medication altogether, indicates that at least for the medium term, he was probably going to have to maintain medication. I think that was an issue that could have been addressed, and perhaps it will be addressed with respect to apparently appellant's pending oral motion to discontinue the medication. Perhaps that's a subject that could be fleshed out below factually as to whether or not, given that we're now in this holding pattern where it may take, it could take until next year to get appellant back into physical court for sentencing, if that's what he insists on. How, is it still necessary to take the medication to maintain him in competence? What would likely happen if he was taken off it? That is perhaps something that could be addressed below, but I don't think that it is reason right now to vacate the order. I think that would be.
Well, I mean, counsel, I don't know.
Yeah.
I mean, I guess the problem is, yes, I mean, it should be subject to some kind of periodic review, right? It doesn't seem like the onus should be on the defendant to discontinue an order that would run in perpetuity, where the trial court did not articulate any findings to suggest, this is going to be medically appropriate in perpetuity. This is going to be, the least intrusive way of doing it. Like, probably what she ought to have done, and I understand she didn't anticipate it, is given some time limitation to it, and then once that time expires, revisit, rather than kind of shifting the burden to the defendant. And I think that might have been Judge Easterly's question. What's wrong with that? What's wrong with saying, they've had their time. If you want to extend it, you've got to start anew. And really, you shouldn't be doing this in perpetuity from the beginning. It needs to have some time limitations on it.
Right. So, and again, this case has been rendered fairly unusual because of the intervening pandemic. It might well have been over by now otherwise. Can a court say, I don't think, though, that in this case, that the trial judge basically just said, I've entered the order and that's it. And I don't really care, and I don't care how long he's going to be. She did schedule, a hearing for the end of March. It's just that it's been very difficult to hold these hearings in the medium term.
I have a factual
I'm sorry,
question.
Go ahead.
I have a factual question, though, that is raised by Judge Steele's questions. He said, there were no factual findings to support a ruling in perpetuity. And I guess I'm wondering, was that a subject of the hearing? Did the doctors talk about how long the medication must be taken? I mean, you said it's not like antibiotics, like you can't just take it and then clear up the infection. I mean, is taking this medication indicated, for a lifetime if you have this kind of targeted delusion, or is it possible to take it for some period of time and then kind of, maybe in conjunction with CBT, beat the delusion and become healthy again? And is that in the record at all?
I don't believe that those, and again, it's possible that Ms. Harden, since she was there, has a better memory of this. I don't recall there being extensive testimony about, in other words, looking out, 2, 3, 4, 5 years, what is the long-term prognosis for someone like appellant? And I certainly don't want to opine as to what's the appropriate long-term treatment for somebody with this very rare disorder.
Right.
I couldn't do that even for a common one. What I can say in this case is that I think judges sort of, they have to sort of take the case in front of them with the expectation that, look, here's where we're going. We're going to trial, we're going to sentencing, but I have an incompetent defendant. The doctors are saying at this point that, involuntary medication is really the only way that we're going to restore this defendant to competence. And then we're just going to have to go from there. I think the expectation is that, yes, I think a judge should, check in regularly on the case. And I think the judge has tried to do that as best she can in this case. It's just that it's not easy to do right now, but I think she's been trying to do that and sort of maintain oversight. But I think there's a difference between saying maintain oversight and saying, well, this order has to sunset at X point in time. Maybe a judge could do that, but I think the expectation is that, the medical professionals are probably going to say, and you can ask them, is it still necessary to do this? And that's something that I think can be revisited by the parties, by the court, as a case progresses.
Right. Well, and I guess that what this brings to mind then is that, maybe we need a remand here, right? Because this is clearly something that just was not considered. I mean, and understandably so, as everybody agrees, like everyone thought that we were going to be on a certain schedule and then we got hit by a pandemic. But in light of the pandemic and the uncertainty that is causing in so many people's lives and in court procedure, maybe there needs to be some supplement to the evidence in this case about the nature of this medication and how long you need it, and maybe a revision to the court's order about in light of that evidence, sort of what the timeframes should be for the forcible medication. And it just seems like that's just not here, and maybe it would be premature for us to say anything about it, but maybe we need to remand the case to the court to look at this sort of additional issue that has come up in this fact-specific situation.
So I think a couple of responses I would make. First, it sounds to me like these questions are going to be addressed in this case. I mean, it sounds to me like the trial judge asked the parties to file, at first a defense pleading and then a government response as to whether to continue the involuntary medication. So it sounds like the judge is already going to do this.
Right, but
I
on
think
that point, it gets a little procedurally messy, right? Because we have jurisdiction over the case, and so she technically can't do anything, even if she wanted to amend the order or vacate the order at this point in light of any new evidence that she heard. The case is with us, and so it might be procedurally cleaner for us to remand it to her to say, the way is clear. Now go ahead and take some more evidence and consider this kind of additional issue that was not obvious to people at the time that you were ruling, but now is an additional aspect to this that we really need to consider to ensure that Mr. Jones's rights are, not being violated.
Okay, so I think certainly returning this case, fully to the trial court is what we would like to see happen. I do think it is important that, in principle, I don't think there's anything wrong with this court, and obviously this court can decide if it so chooses to do so, asking the trial court to, revisit this question of how long the order should continue. I think the important thing, though, is that what's presented here today was the original order in violation of SEL and the statute? I think the answer is no, it was not in violation. It was a valid order, and certainly, an appellant's challenges to its validity, we would respectfully submit should be rejected. We think the order should be affirmed, and it certainly should not be vacated or stayed or suspended such that appellant would stop receiving medication, because we think at this point that would probably be extremely detrimental to the future progress of this case. If it is remanded with instructions to have a hearing, in principle, we are not opposed to that, provided it is clear that the order as originally entered is valid. It's not being stayed or suspended or vacated, certainly. But there are if this court chooses to instruct the trial court to, have a hearing to determine whether it is necessary to continue the order, that's something that I think the government is prepared to do. Obviously, we would need a certain amount of time to get, reports and to prepare testimony from the doctors as to what should happen, given what we think is the probable timeline of this case. I think, though, that the important thing is that it should be clear that this order is valid and it shouldn't stop upon remand, because we'd respectfully submit that certainly the record right now before this court suggests that if appellant is told you don't have to take the medication anymore, he probably won't. He certainly won't take a therapeutically effective amount, and it's quite likely that he might revert to becoming incompetent, and then we'd be back at square one. And we would respectfully request that that's not what the court be instructed to do. At most, we think it would be appropriate to remand with instructions to have a hearing, as to whether to continue the hearing, but whether it should continue and for how long, that the order should remain in place.
All right, thank you.
Thank you.
Ms. Harden, we reserved a few minutes for rebuttal for you.
Yes, and I'm mindful of the court's time. There are a few things that I do just want to say. First, Your Honor, with respect to the court's order below, the order is just not valid. That's Mr. Jones' position. The government did not provide a particularized medication plan, nor did they explain in detail any measures to minimize the risk of the side effects, let alone any measures that might limit or ameliorate the trauma that's associated with involuntary medication. And Bush said, Your Honors, that to approve of a treatment plan without knowing the dose range would give medical staff carte blanche to experiment with what might be dangerous drugs or even dangerously high doses of safe drugs. And like I think Judge Easterly asked me whether the court should be responsible for micromanaging. My position is absolutely not. I recognize that the exact precision in stating a dosage range is not necessary, but the government must provide a reasonable range to allow medical providers to adapt to the treatment or to adapt to treatment that may cause all kinds of physical responses to the medication.
Well, why don't we have that here? Why isn't up to 25 milligrams dosage range?
So, Your Honor, the court, obviously, recollection is what's guiding here, but I don't believe it was up to 25 milligrams. I believe it was just 25 milligrams. That's just it. And I think
it was up to 25 milligrams, and I think that's from the transcript. Well, it comes from a reference in the government's brief to the transcript of February 12th, 2020. So
I defer to the court on that, but I do believe thank you, Your Honor. I would say this, the reason that the court doesn't have that here, and I think Judge Easterly asked me a sort of hypothetical, which would be obviously different, but here you had a baseline that would allow you to know what allowed Mr. Jones to become competent. So here it's different. You need a dosage range because you have a baseline of knowing that there was sporadic medication that allowed him to be rendered competent. So to go all the way to even up to 25 milligrams, it is just not something that the court could make a reasoned determination that the medication was necessary to render him competent without having what the minimal dosage was that rendered him competent in February of 2019. And so that's Mr. Jones' position on why it is that the court does not have a sufficient range and why that part of the order is deficient. Also, Your Honors, the government failed to meet their burden that involuntary medication is necessary to further those interests. That is, that there are less intrusive treatments that are unlikely to achieve the same results. And I want to be clear, I am not saying that it would have been medically appropriate for the court to forcibly medicate Mr. Jones just at a lower dose. That is not my argument. The less intrusive treatments that should have, or that were likely to achieve the same results would have been CBT, which although there was testimony that because of the delusions, Mr. Jones was unable to participate. There had not been any meaningful participation in CBT to make that determination. And so the court's assessment that the government had met that by clear and convincing evidence was just not proper. There were also no other kinds of therapy that were considered. One of the things that the court may have is that in the DBH reports is that Mr. Jones was in fact participating in both individual and group therapy. He had attended the mock trial group and had also attended the therapeutic learning center for purposes of therapy. And so there were lots of other therapeutic options that could have been considered that were not considered in determining whether they could achieve the same result. Finally, the government failed to carry their burden with respect to the administration of the drugs being medically appropriate. And again, I think I've talked a little bit about this in terms of risperidone, and the court has said sort of going up to 25 milligrams. The government indicates that no binding authority holds that greater specificity is required. And I would ask the court and direct the court to United States versus Gamara, which is 940 F3rd 1315 to 2019 DC Circuit case. And while the government says that no binding authority holds that greater specificity is required, Gamara says that an individualized medical plan should detail any measures to minimize risk of side effects and measures that might ameliorate the trauma that's associated with the administration of the medication. And here, the record supports that the doctor's attempt to ameliorate the side effects was to say, hydrate yourself better and take pain relievers. I mean, that is just not the kind of individualized medical plan that the court was required to review in determining that the administration of drugs was medically appropriate. I believe one of the reports also indicates that the doctors either offered or required, gave Mr. Jones Benadryl. Without an individualized medical plan, there's just no information before the court on the efficacy of the side effects that he's experiencing. That is urinary incontinence, the tremors, the headaches, the grogginess, that would in any way alleviate any of the side effects. And so that information was insufficient as well. I make my final point, Your Honor, with respect to the court's order not having any sort of time limit. And I think one of the things that's a problem here is that the government continues to say, sort of consistent with what the court may or may not say, is that he needs to stay on the medication in order to remain competent. But that's just not what the law requires. The law requires that the forcible medication can only stay in place to keep him competent. And at this juncture, there's no information that's before the court that would allow the court to say, well, he does need to stay on it in order to maintain his competence, which is sort of an obvious showing to the court that the government does expect for this to last sort of into perpetuity. Even after he's achieved competence, the government says, well, we know he's achieved competence, but we might as well keep him on the medication because he's likely to revert back. CEL just doesn't authorize sort of this extra period of time after the direct point of being competent has been achieved. And I think that for all of those reasons, the court's order is deficient on its face. The government says that the court should not vacate the order. The court should vacate the order at this juncture based on the record that Mr. Jones has been found competent, and there's absolutely nothing in the record that indicates that this order is ever supposed to stop. So for all of those reasons, I ask that the court vacate the trial court's order.
All right, thank you. I'd like to thank both the counsel, Ms. Harden, Mr. Coleman, for your briefs and arguments today. We'll take your case under advisement at this point, and we stand adjourned.
Thank you, Your Honors.
This court is now adjourned.
Okay, and